Okay, thank you all for joining today's webinar on the security deposit provisions of the AIR CRE lease. For those who don't know me, I'll start with a brief introduction. I've been a real estate lawyer for over 20 years. I led the real estate practice at one of the oldest firms in downtown Los Angeles. In 2017, I started Consensus Legal, and our law firm focuses on commercial sales and commercial leasing transactions. Regarding the AIR CRE contracts, you probably all know they are very well drafted, very thoughtfully drafted. They make transactions easier and more efficient because we're all starting from a point that we're familiar with the contracts. And in my opinion, they are the best contracts, most widely used in California, probably nationwide, in terms of commercial real estate contracts. So the format for today webinar, the presentation on security deposit provisions will be 20 minutes. After the 20 minutes, I'll stay on for questions and answers. And as I mentioned a moment ago, if you have questions along the way, please put them in the chat box and I'll try to check it from time to time. Final note before we begin, we are not affiliated with or sponsored by AIR CRE. I'm not providing legal advice during these webinars. It is for education and discussion purposes. Okay, so today's webinar, we will focus on security deposit provisions in the AIR CRE leases. And you may be thinking, do security deposit provisions really matter? I mean, typically we just put the amount of the security deposit on page 1 of the AIR CRE lease. And then we oftentimes, hopefully, if you're a lessor, you don't really worry too much about the security deposit during the lease term. But in this webinar, we will get into some of the nuances. So let me share my screen. And some of these nuances will be important in terms of protecting the lessor in various situations. So I'm going to share the AIR CRE lease, scrolling up to paragraph 1.7 of the AIR CRE lease. And this is just the page 1 provision. Base rent and other monies due upon execution. Many of you have completed AIR CRE leases, and paragraph 1.7C is where you put the amount of the security deposit. And to keep you on your toes, I'll give you a little bit of a pop quiz. Let's say the security deposit in 1.7C, let's say it's $10,000. The security deposit that's been agreed upon, it's in the LOI, it's $10,000. Does that $10,000 security deposit increase automatically as the lease goes on? I have a couple head shakes, no.
No.
Okay, so let's hold that thought, and we will get to it a little bit later. So, because I think I got some of you on that one. So we'll now scroll down to paragraph 5 of the security deposit of the AIR CRE lease, which is the security deposit paragraph. And just by way of background, we'll discuss the basic provisions of the security deposit paragraph, the provisions that lessors expect to see in any commercial real estate lease. And those are sentences 2 and 3 of paragraph 5. If lessee fails to pay rent or otherwise defaults under the lease, lessor can apply the security deposit for really anything that's due, any amount that's already due, any rents that will be due in the future, and also to compensate lessor for any liability, expense, loss, or damage which lessor may suffer as a result of the default. So that's the basic concept of the security deposit. If there's a default by lessee, lessor has the right to apply the security deposit. The third sentence is restoration of the security deposit. So if the lessor does in fact apply a portion of the security deposit, within 10 days, lessee has to restore the security deposit. So in that scenario where the lessor utilizes the $10,000 security deposit, lessor can give lessee notice, and lessee is required to restore it to $10,000 within 10 days. As a practical matter, many of you have probably seen it. Lessors often do not apply the security deposit if lessee has not paid its rent. It's more common for a lessor to, for example, serve a 3-day notice for the lessee to pay the rent, but retain the security deposit to not apply it. But of course, the lessor has the right to do so. So this fourth sentence of paragraph 5 gets to the pop quiz that I may have gotten some of you on. And this is a little known provision of the AIR lease, but it's a fascinating one. If the base rent increases during the term of the lease, lessee shall, upon written request from lessor, deposit additional monies with lessor so the total amount of the security deposit shall at all times bear the same proportion to the increased base rent. So in short, if you have 3% annual increases in the base rent, the security deposit can increase by 3%. It doesn't happen automatically. It happens upon written request of lessor. So, and I see someone raise their hand. If you have a question, feel free to put it in the chat box. That'll probably be the easiest way to deal with it.
Discuss the security deposit issue.
Sure, we can hold it. If you want to discuss it, we can do it during Q&A, if you don't mind, Greg.
Okay, thank you.
Thank you, appreciate it. Okay, so that's, and many times lessors do not use this right. It's pretty rare. Over my 20 plus years, I've only seen it used on a handful of occasions. Nevertheless, lessor does have the right. If the base rent increases annually by 3%, they can increase the security deposit. The next item we'll go over is a scenario where the AIR lease provides some protection to lessor in a scenario where the agreed use changes. So if the agreed use that the parties have stated on page 1 of the lease, if the lessee needs to change the agreed use because its business has changed or because it is subleasing the premises to a subtenant that is engaging in a different use, so the agreed use needs to be amended. In that scenario, the lessor has the right to increase the security deposit in its reasonable judgment to account for increased wear and tear to the premises. I've seen this sometimes in industrial leases where there's going to be more wear and tear to the premises, to the parking areas, etc. Sometimes you'll see it in a retail context as well. But that's a scenario where the lessor is entitled to increase the security deposit reasonably. The next situation where the lessor can increase the security deposit is a change of control. So during the term of the lease, lessee sells its business. And if as a result of that sale of the business, the financial condition of lessee is significantly reduced, then lessor can increase the security deposit to a commercially reasonable level based on the change in the financial condition. And you may have seen it in my practice. We've seen it a good number of times. Lessee sells its business to a private equity firm. The private equity firm comes in and takes cash out of the company, maybe out of the operating entity, and lessor is left with an entity with very little assets. So under this provision, the lessor has the right to reasonably increase the security deposit. So those are some of the key provisions in paragraph 5. There are some other provisions in the AIR CRE lease that lessors should be aware of that are not in paragraph 5. And there's 2 more situations I'll discuss before I turn it over for Q&A. The first relates to environmental. So paragraph 6.2 of the AIR CRE lease relates to hazardous substances. There are limitations, of course, on hazardous substances that can be brought onto the premises. And paragraph 6.2a provides lessee shall not engage in any activity which constitutes a reportable use of hazardous substances without the prior written consent of lessor. So a reportable use, just to give you all a little bit of background, there's 3 categories that constitute a reportable use. One is the installation of an above or below ground storage tank. Another is, the use of hazardous substances that's going to require a permit. And third, the presence of hazardous substances, which requires, pursuant to applicable requirements, applicable law, notice to be given to a person entering the premises. So if there's a reportable use, lessee has to get lessor's prior written consent. But at the end of this paragraph, I wanted to point out this key provision that gives lessor some additional rights here. Lessor may condition its consent to a reportable use on such additional assurances as lessor reasonably deems necessary, including but not limited to installation of protective modifications such as concrete encasements and or increasing the security deposit. So here is another scenario. If lessee is going to engage in a reportable use, lessor wants to give its consent to the reportable use. It wants lessee to be able to operate its business. It wants lessee to succeed in the premises. It can give its consent, but it can condition that consent on an increase in the security deposit. And the last provision that we will discuss before Q&A are alterations. So this is in paragraph 7.3 of the AIR CRE lease, utility installations, trade fixtures, and alterations. 7.3b, in essence, requires lessee to get the prior written consent of lessor before making alterations. There is an exception. We won't get into it in this webinar. But let's say lessor is concerned um, about lessee's alterations, in particular, the extent of the alterations. Maybe lessee isn't that financially stable. Lessor might be concerned about mechanics liens that could be recorded against its property if lessee doesn't pay the contractors and subcontractors, etc. So under the AIR CRE lease, this last sentence of 7.3b, if the work costs more than 1 month of base rent, so if lessee is making alterations or utility installations that's going to cost more than 1 month of base rent, lessor may condition its consent upon lessee providing a, a lien and completion bond in an amount equal to 150% of the estimated cost, or lessee posting an additional security deposit with lessor. So that is another scenario where lessor can get some additional protections if it's concerned about lessee's ability to pay for alterations, etc. So with that, I will stop my presentation. I will take a look at the chat box. There's some questions here. Michael asks, I believe your question was, does the security deposit increase over the term of the lease? Yes, that's right, Michael. As we discussed, upon notice, lessor can increase the security deposit as the base rent increases. Greg, why don't you go ahead and ask your question before I get to the others?
What I've found to simplify everything is I figured the security deposit on the last month's rent. So then I never have to worry about increasing on a yearly basis. When I
Yes.
make a modification of terms and conditions, and perhaps an extension, I do the same thing. I add to the security deposit for the last year of the extension.
Yes.
And that's all going to be payable with the first month's rent of any extension. And I found that to work a lot better and make it easier on everybody to understand what they're doing. So
yes, thank you for that practice pointer, Greg. That is very common and a lot of people do it, and it makes a lot of sense. I will mention though, even in that scenario, Greg, it may not be intended, but let's say you start with $10,000 in base rent in year one, and in the final year of the lease term, the base rent is $12,000. So under your scenario, Greg, your practice is to put a security deposit equal to $12,000.
I actually do 2 months always. So
okay,
it would always be 24 because you never know when your tenant's going to try to apply the last month's rent to your security deposit. And this way, you have some recourse. So
yeah, and in that scenario where it's 24,000, the lessor still has the right under that sentence that we went over to increase the security deposit 3% each year. So it can increase it. It's not intended by the way you've drafted it, but just to let you know, the terms of the lease provide that as the base rent increases by 3%, even under that scenario where it's 2 months of the last year's rent, it can still be increased. I'll move on to some additional, some additional questions. Sure, of course. David asks, can a security deposit increase happen automatically? No, David, it doesn't happen automatically. It only happens after lessor provides written notice. So the base rent increases by 3%. Lessee is not required to automatically add to its security deposit. It only does so if lessor provides notice that it's increasing it. Frank asks if the landlord has not proportionately increased the security deposit for several years and then decides to increase the security deposit, can landlord increase retroactively? I think so. I think so. Jin asks, how would lessor know lessee took equity out of their company? That's a really good question. Really good question. So in the reason lessor would know is for a sale of a business, and I'll share the screen. Yeah, why don't I share it so I can show you and everybody else. So the reason lessor would know is because it constitutes an assignment of the lease. So in 12 point, in paragraph 12, assignment and subletting, 12.1b, the transfer of 25% or more of the voting control of lessee shall constitute a change in control, and a change, and then I have to go up. A change in control constitutes an assignment requiring consent. So if that private equity firm is buying lessee, and it's, let's say it's buying the stock of lessee or the membership interests or whatever, and it's buying more than 25% or more, that constitutes an assignment under the lease, and lessor's consent is required. And in that scenario, many lessors will say, okay, well, we need information about the buyer. We need to know, it's how much experience it has in this business. We want to know what the financial condition of the business will be post-closing. So the lessor in that scenario, Jin, can ask for like pro forma, post-closing pro forma financials, what the balance sheet will look like, for example, immediately after the closing. And those are the types of questions it can ask to get into the details of what the financial condition of lessee will be post-closing. David asks, when a lessor commingles a security deposit with its general funds, must it state it is not a trustee of the security? Yeah, under California commercial leasing standards, it can, it can be in its general account. It doesn't need to be segregated as set forth in the AIR CRE lease. Michael asks, yeah, I think that question has already been addressed. Ty asks, can the security deposit be used for the eviction process? I'm not sure if I understand that question. Maybe you can elaborate or clarify, Ty. I'll move on to the next question. In the meantime, after the first of the year, will lessors be limited to 1 month of security deposit under the new legislation? Kevin asks that I'm not aware of the new legislation. I don't know if that applies to just residential. Many of these limitations and landlord-tenant relationships apply to residential, but I don't know the answer to that. Kevin, my apologies. Is there a maximum security deposit allowed? Frank asks. Under residential, I believe there are limitations on the amount of the security deposit. I think I know the answer, but I won't take a crack at it. But under commercial, with commercial leases, I'm not aware of any limitation. I've seen, 6 months longer. If the parties to a commercial lease agree, then that's generally good enough, as far as I'm aware. under the Lee asks, under the alteration paragraph, the landlord increases the security deposit by 50%, and all contractors have been paid, and lessee has all required permits. May lessor keep the increased security deposit? Good question. Until the end of the lease, because said improvements must be removed at the end of the lease. Very good question, Lee. You are risking stumping me, so I have to give you some credit here. I think I know the answer to this, but I'm just going to go back to paragraph 7.3b, and it's a very good observation. And it says, for work which costs an amount in excess of 1 month's base rent, lessor may condition its consent upon lessee posting an additional security deposit with lessor. As you allude to, it seems it doesn't say that it has to be returned. It doesn't say that when all amounts have been paid. And by the way, it doesn't say that the security deposit is used solely to protect lessor against mechanics liens. So my perspective, Lee, would be that it doesn't have to be returned. Sometimes we see what I would call restoration deposits, where it's going to be expensive for lessee to restore the premises at the end of the lease term to the required condition. And so lessor gets an additional restoration deposit to protect lessor. So my perspective at first glance is that it does not need to be returned. Lessor can keep it until the end of the lease term. Sam asks, if we did not ask for so if the security deposit was not requested at the time that lessee requested lessor's consent to the alterations, can lessor request the increased security deposit later, such as right before construction begins? I think that is what Sam is getting at. And I think, Sam, I would probably say no. And the reason I would say that is because lessor is entitled to increase the security deposit as a condition to its consent. So if it's already consented to it, I don't think it has the ability to ask for that increase anymore. We have about 10 more minutes. Ty clarifies, can the lessor use the security deposit to pay for an attorney to evict lessee if they are in default? Good question.
The answer is located in chat under Michael at the very end. I answered that question.
Oh, okay. Let's see what Michael's answer is. Upon unlawful detainer, landlord reconciles all amounts owed by tenant, which is then submitted to obtain a money judgment. So the security deposit should be credited to that judgment owed. I think I agree with that, Michael. Yes, the landlord cannot double dip. It's definitely goes toward the payment of the damages. And Ty, yeah, the security deposit, if lessor wants to apply the security deposit before it gets the judgment, for example, to pay for the legal fees, I don't think that's an issue, and I'm just going to confirm by going down to okay, so we talked about how lessor can use the security deposit for any default, for any damage or expense it incurs in connection with the lessee default. So if lessee fails to pay rent, then the security deposit can be used for the expenses of an attorney. That's my perspective off the cuff. And just going down to paragraph, there is a provision, here it is, paragraph 31. And it specifically allows lessor shall be entitled to attorney's fees, costs, and expenses incurred in connection with the preparation and service of notice of defaults and consultations in connection therewith. But what you're talking about is maybe even beyond that. But yes, I believe, Ty, that it can be used for that purpose. David asks, will a tenant's security deposit be swept into tenant's bankruptcy? Is there a workaround to prevent that? What a question. I love it. Yeah, great question, Dave. And that's where we get into security deposits versus letters of credit. And a security deposit will generally be included in the bankruptcy estate. And the benefit of a letter of credit, I think maybe people know where I'm heading with this letter of credit. The benefit of the letter of credit is a letter of credit does not go into the bankruptcy estate. And the reason is it's viewed as a contract with a third party because it is a third party bank. Instead of that $10,000 security deposit given by lessee, if instead a bank, lessee's bank, issues a letter of credit to lessor for $10,000, that is a contract in essence between the bank and lessor. And so that does not get swept up into bankruptcy. And that is the key benefit to lessor of a letter of credit. Great question, Dave. Can we ask for security deposit amounts to be the full amount of the construction cost until the project is completed? If it's reasonable, I think so. Now, whether it's reasonable probably depends on a lot of facts. But I think if it's reasonable, I think it's okay. Ty asks, yep, well, we kind of just talked about what do you think is better for the lessor, a security deposit or a letter of credit? For bankruptcy purposes, absolutely a letter of credit. But outside of bankruptcy, some lessors like to have that money in the bank. So, with letters of credit, there's also transactional costs. It can take time. It can slow down the signing of a lease. You can get around it, but oftentimes lessors, before they sign a lease, they will want the letter of credit to be finalized by lessee's bank. And that can take a little bit of back and forth. And then there's, costs associated with that. Oftentimes, AIR CRE leases are completed without attorneys. If you kind of get into the letter of credit realm, it's probably something that an attorney will need to be involved in. So yeah, there's advantages and disadvantages. The questions keep coming. It's great. Upon UD, landlord reconciles. Oh yeah, okay, yeah, you mentioned that, Mike. Thank you. Kyle talked about limitations on security deposits for qualified commercial tenants. And yes, maybe that is a good topic for an upcoming webinar. I'll look into that, Kyle. Thank you. Yeah, that seems like a great topic. And this seems to be the last question. Yeah, Sam's talking about this is kind of related to his prior point about having an increased security deposit equal to the construction cost. Reason being that you don't know the construction cost until the permit is issued. Yeah, and a completion bond is another way to cover it. That's right, Mike. So those appear to be all the questions. I was hoping not to be stumped. It looked like you guys did stump me on the limitation on SB 1103. You're horrible. I'm just kidding. I appreciate it. I love it. I love the challenging questions. Really enjoyed this webinar. I will stay on for a few more minutes. I'm going to stop the recording, but I'll stay on for a few more minutes if anyone has any kind of more specific questions they wanted to ask me. Thank you all so much for joining. Appreciate it. And we'll hopefully have a webinar next month. Thank you.